say that the first Matrix film is one of my favourites, because not only did it completely turn around your potential view of the world, but I mean, imagine that scenario where that in fact is your virtual game, where it's all completely real and you live your life coming pretty close to thinking this is what it is. The more we approach that reality, the more you can have real world expectations of protection. And you know, the level of detail that you saw in Matrix will be some time away, but surely it's just a matter of time before it happens. And I think when you get to that stage, you're going to pretty much need, it's really hard to know, but you're going to need great levels of certainty before people will invest a lot of money.
I just wanted to ask about, in general terms with contracts, you mentioned American and British law earlier. With jurisdiction, how do you handle a situation like that where we're Australians and we're dealing, for example, with an American publisher for whatever, and they're insisting heavily on jurisdiction in the US?
Yeah, really
and also
interesting.
Jurisdiction here in Victoria or wherever.
Yep. Where to start? It's a great question, some complex answers. Let me start by saying that there are kind of three ways in which the courts look at the problem. The first is, in the absence of an agreement, it looks for connecting factors between the activity. Developer in America, service provider in Australia, where's the activity going on? Was there a contract signed here? Was a contract signed? It looks at the connecting factors, which can frankly sometimes be fairly balanced, but the court will need to make a decision one way or the other. The best way to resolve the issue is in a contract, and I'll come back to that. But nevertheless, regardless of what's put in the contract, there are some laws which just go, I don't care what you've got in the contract. Australian trade practices laws, for example. You can't get around laws by just saying, if you're not playing in your turf, American law overrides. Some laws just stick there. Going back to the issue of putting jurisdictional clauses in game contracts, it can be a really big issue. Practically, let's say there's a dispute. You get your lawyers involved, and they look at the contract and they might say, oh, well, they've breached it there, you can take action against them. They get down to the end which says this contract's governed by the laws of California, and they then say to you, right, we're going to need to start doing some California lawyers whose hourly rates are probably $500 or $600 US an hour. And you go, it's at the time. Let's try and find some other way of dealing with this. And then you've got, might not just be the law that applies, and that you can have scenarios where you're battling it out in the courts of Australia, but applying American law. Or you can have American law in American courts. And the American judicial system is, in many ways, very different to ours in terms of its practice. A really big example is how they deal with legal costs. In Australia, lawyers are pretty litigious. Some companies like a good fight, Chapter 7 being an example. One thing that tends to steer people a little bit away from litigation is the fact that if you lose, you're going to pay all your lawyers' fees and a large proportion of the winning sides too. And if you've got a big fight, that can be millions and millions of dollars. In America, however, the basic position is that whatever happens, you only got to pay your own lawyers' fees. And so you might be a small company, you might get a lawyer who's got a fairly cheap hourly rate, so willing to do it on spec. If they're willing to do it on spec, what do you care? Where do you go for it? You know, you lose the case, all right, but you're not up for the millions and millions of dollars of legal fees. And if you're the aggressor, if you like, you lose the case, it's lost a bit of time. So that's one of the reasons why I see a lot more litigation America. And so, if your contract has that provision in there, clearly the dynamics of the way in which these things can be resolved can be sorted out. I saw one contract once which had a dispute resolution clause, which was between two Australian companies, and the other lawyer had put Hawaii in there as the place to resolve disputes. I said, mate, we're not Hawaiians here. And he goes, yeah, wouldn't it be great? I hope that answers the question briefly. Anything else?
Sort of, to do a second life, recently, I can't remember how long ago, was that issue with that little part behind the shopping malls?
It's ringing a bell.
Children, like offering children's services through affiliate kind of ending.
Right.
There was a huge hullabaloo about it because what's the second life, the little labs pretty much said, we let people do anything they want.
Yep.
We're not responsible. But of course, morally and ethically, the world said, hang on a minute, you facilitate this behaviour.
Yeah.
They need to protect themselves very well in that situation. They do not have to pull everything off and make blatant apologies. But how would you go about protecting that kind of thing? If you let people crack whatever content they want, and then somebody did crack the spark. And the issue was that nobody knew who was crying the little children out. Was it other people of age? Which then would mean, well, it's fancy role playing against adults who do whatever they want behind closed doors. And in this case, it was behind a wall. Whereas it isn't with the children, it's somebody who coaches children in bullies, or etc. etc. So it's all over the news, it's very disgusting. There were no sort of hints about it, so it was like blatant blocking this or that. How does that get handled?
Well, look, from a legal perspective, a developer can put into their terms of use endless paragraphs talking about if you do this, we can remove you, if you do that, we can remove you, pornography, racial vilification, discrimination. They can put all the stuff in there which would give them the mechanism, if you like, to remove content without real legal recourse. So legally, that's how they can do it. There are, of course, great practical difficulties that you've alluded to. Who's actually doing this? Are we going to spend all our time racing around trying to find stuff that's going on? Will we just rely on people reporting it to us and then trying to work out whether we should step in? And the challenge is they're really playing the roles of courts. And there are some devilish court decisions out there, but usually courts are fairly good at balancing these things, weighting different evidence. That, you know, professionals who kind of get on with that well. And you put it into the hands of a developer, and can be a big responsibility. I mean, is this a freedom of expression thing under the American Constitution? Is this just horrible pornography which should be stamped on? You know, you have to run through the whole thing to get two people complaining to each other, trying to find the balance there without running it through a proper court system is a great abbreviation. Now, that could well be a good thing. Courts can take many years to make decisions, and a benevolent dictator can sometimes be a wonderful way to keep things running smoothly. So, look, it's an ongoing challenge. I mean, in a sense, you see the same thing with bulletin boards. You know, companies, and you're seeing a bit of a progression here. It started with kind of a utopian perspective of, hey, we're just a toilet wall. Anyone can come and scribble on. It's not us, it's them. But that tended not to work so much in practice. I was involved in one of the first internet defo cases, and a well-known Sydney lawyer was defamed rather horribly on my client's site, and he was using a pseudonym, and there was defamation to do with his pseudonym, and as I recall it, he then made it known who he was. Don't you know who I am? Of course, when he said that,